So today we'll be having an info session on antenuptial contracts and the legal consequences of a marriage. Joanne, what are the formalities for a marriage to be legal in South Africa?
So I would say first things first, that you have to ensure that you're legally allowed to get married and you know the consequences of marriage. Since in South Africa, if you do not have a contract concluded beforehand, your marriage is automatically in community of property. So what would happen on the day of your wedding, you will have to sign a marriage register together with 2 witnesses, and then the marriage officer will then issue you with a handwritten marriage certificate. Thereafter, the marriage officer will then submit the wedding register to the Department of Home Affairs, whereafter the details of the marriage will get recorded in the National Population Register.
Now, what if one of the future spouses lives abroad?
So in South Africa, we follow the principle that you follow the domicile of the male, so of the husband basically. So if the husband, for example, was domiciled in Mauritius, then the laws of Mauritius would be applicable to the marriage.
What is an antenuptial contract?
So an antenuptial contract is also commonly referred to as an ANC, and as we refer to it overseas as a prenup, as a legally binding contract between 2 prospective spouses who wish to enter into a marriage. The antenuptial will determine which marital regime will be applicable to the marriage and how the individual parties will decide on how to deal with their assets and their future estate.
Then probably one of the most important questions are what matrimonial property regime will be regulating your marriage. So in South Africa, we have 2 main systems. We have the out of community of property and the in community of property. And within the out of community of property, we have 2 further systems that can apply, the accrual system and without the application of the accrual system. In community of property is where what's yours is mine and what's mine is yours. So both parties share equally in an estate, and they both share assets and liabilities, which places their assets at risk.
Where parties are married out of community of property, they usually have to conclude an ANC as previously mentioned. And it also means that whatever assets you brought into the marriage will be your own assets, and then whatever debts and liabilities will also be your own debts and liabilities. There will never be a joint estate between the parties. However, you get an out of community of property with the application of the accrual system, and you get a marriage out of community of property without the application of the accrual system. The accrual is basically the calculation that gets used either on death or divorce to determine the value of both estates and whose estate is bigger. So with the accrual, if you married with the application of the accrual, so the spouse whose estate has shown the smaller amount of growth will share in half of the difference of the growth accumulated between the 2 estates basically. And then if you married without the application of the accrual, basically on death or divorce, each spouse will unfortunately just have those assets that they had when they entered into the marriage and whatever they accumulated during the marriage, and the same with liabilities and debts.
Let's say we have spouse A and spouse B, both started with a commencement value of 0. And at the end of the marriage, either by death or divorce, the one spouse, let's call him spouse A, estate has a value of 1 million rand and spouse B 2 million rand. So spouse B obviously has the bigger growth. Now the difference in the 2 growths will be 1 million rand, so it's 2 mil minus 1 mil, it's 1 mil. And then the half of that will be 500,000 rand. So then spouse B would have to pay over to spouse A an amount of 500,000 rand. So spouse B will end up with 1.5 million and spouse A will end up with 1.5 million. This is known as the Ferris system. If spouses are married in community of property or have been for the past 10 years, is it possible to change the marriage regime?
So it is possible to change the matrimonial property regime which governs your marriage, but it is a costly and time-consuming process. You have to, for example, approach the High Court to bring your application, and there are certain factors which have to be taken into account. One of the important things which the court will look at is your creditors, if you have any, and how the registration of a post-nuptial contract would affect your creditors basically. You, for example, then have to place an advert in the newspaper allowing your creditors to actually come forward, and should they have any objection thereto, they will inform the court thereof. Thank you for joining us. I think that answers most of our frequently asked questions by our client. Please join us for our next video, which will be on tips for first-time home buyers.